behalf of the United Nations and on behalf of the Cambodian people today, the Supreme Court Chamber of the Extraordinary Chambers in the Courts of Cambodia for the prosecution of crimes committed during the period of democratic Cambodia pronounces the final judgment on the appeals by Khieu Sampon and the co-prosecutors in case 002/02. And we have the same judge bench composition except Judge Maureen Herring-Clark, who resigned from the ECCC, and the Supreme Court Chamber have a reserve judge in his place. It's Judge Philip Raposa for the proceeding. Also, please inform that Judge Philip Raposa have followed the procedures and the proceedings at the chambers during the trial judgment, as well as in the cases of 002/02 from the beginning. For that reason, he is full-fledged in the proceedings before us. Graffier, could you report the attendance of the parties and the council? Graffier, Mr. President and the bench. All parties are present. As for the health of the accused, Khieu Sampon, this morning is stable and that he is able to attend the court proceedings, and his health is being monitored by a medical team. Thank you. The present case, known as case 002/02, involves some of the most heinous events that occurred during one of the most tragic and catastrophic periods in human history. Between 17 April 1975 and 6 January 1979, the Communist Party of Cambodia, CPK, also known as the Khmer Rouge, ruled Cambodia, which was then known as Democratic Cambodia, DK. After seizing power, the CPK launched a nationwide socialist revolution through a great leap forward aimed at building the country, defending it from enemies, and radically transforming the population into an atheistic and homogeneous Khmer society of worker peasants. During the DK era, the civilian population was denied basic freedoms and subjected to widespread acts of extreme cruelty. A culture of fear prevailed through mass killings, torture, violence, persecution, forced marriage, forced labor, enforced disappearances, and other inhumane treatment. The CPK's rule was marked by some of the worst excesses of any regime in the 20th century, during which an estimated 1.5 to 2 million Cambodians died. This case has been fraught with difficulties. Severance of the closing order in case 002 necessitated 2 consecutive trials on separate charges for the same 4 accused. That step was taken for trial management purposes and in light of the frail health and advanced age of all 4 accused. 3 of those charged have since died. The majority of the case file material has been translated or interpreted into 3 languages, In addition to those challenges, the world was struck by the COVID-19 pandemic. This necessitated a Herculean effort, creativity, and resilience on the part of every staff member of each organ of the court. As a result, the case successfully moved forward and the judgment was completed. Accordingly, all procedural, factual, and legal issues subject to appeal have been duly considered and decided by all judges of the Supreme Court chamber. Furthermore, the chamber, mindful of the accused's continued frail health and advanced age, considers it judicially prudent to ensure that the judgment is pronounced expeditiously. The judgment in this case concerns Khieu Samphan, who was found criminally responsible for his role in events involving the Khmer Rouge following a lengthy trial. The appeal judgment is several hundred pages long. I will now pronounce a summary that highlights only the key findings and rulings of the Supreme Court chamber in its deposition of this case. The full text of the judgment will be made available in due course after the editorial and translation process is completed. Only the full written judgment is authoritative. Khieu Samphan was born in Svay Rieng province in 1931 and had a long and significant political career in Cambodia. He became a member of the circle of the leftist Khmer intellectuals studying in Paris in the 1950s, while pursuing university and doctoral studies in France. He eventually rose to prominence both in the run-up to and during the DK era, holding various high-level positions in the CPK, including President of the State Presidium and in the government of DK. On 16 November 2018, the trial chamber of the ECCC rendered its judgment in case 002/02 in summary form and notified its full written judgment on 28 March 2019. In that judgment, the trial chamber found Khieu Samphan guilty of the crimes against humanity of murder, extermination, deportation, enslavement, imprisonment, torture, persecution on political, religious, and racial grounds, and other inhumane acts comprising conduct characterized as enforced disappearances, forced transfer, forced marriage, and rape in the context of forced marriage, and attacks against human dignity. Khieu Samphan was also convicted of both genocide by killing members of the Vietnamese population and grave breaches of the Geneva Conventions, namely willful killing, torture, inhuman treatment, willfully causing great suffering or serious injury to body or health, willfully depriving prisoners of war or civilians the rights of fair and regular trials, and the unlawful confinement of civilians. The trial chamber found that although Khieu Samphan did not commit these crimes with his own hands, he was criminally liable for most of them as part of a joint criminal enterprise, and for some of them by aiding and abetting their commission. The trial chamber imposed a sentence of life imprisonment on Khieu Samphan, merged it with the life sentence imposed on him in case 002/01, and ordered that the sentences be served concurrently. It also partially granted the civil parties' request for moral and collective reparations and endorsed 13 specific communal memorial projects. Kirsten and the co-prosecutors filed appeal briefs and separate responses, and the civil party lead co-lawyers made written submissions on behalf of the civil parties. On appeal, Kirsten alleges that the trial chamber committed approximately 1,824 errors and challenges the bulk of the trial judgment. In doing so, he alleges error in the issuance and pronouncement of the judgment by the trial chamber, and also alleges errors relating to the fairness of the proceedings, the scope of the judicial investigation and trial, the underlying crimes, and the issue of individual criminal responsibility. He asserts that the alleged errors require that his conviction be reversed and his sentence be vacated. The Supreme Court chamber notes, however, that Kirsten makes no apparent challenges to the trial chamber's specific findings regarding the charge of grave breaches of the Geneva Conventions, although his appeal cites a number of errors that called into question the general integrity of the proceedings before the trial chamber. That would also apply to its consideration of that charge. His appeal relating to the grave breaches of the Geneva Conventions is limited to those alleged errors. The co-prosecutors advance a single ground of appeal, challenging the trial chamber's ruling that forced sexual intercourse in the context of forced marriage did not constitute the crime against humanity of other inhuman acts in the case of male victims. The Supreme Court chamber heard the parties' oral submissions on the appeals from 16 to 19 August 2021. The chamber then retired to deliberate, and today it renders its judgment on both appeals, which I shall address together as is done in the full written judgment. Due to the significant number of appeal challenges raised by Kirsten, at this hearing I shall pronounce only a summary of our findings and rulings along with the disposition. The Supreme Court chamber's findings and rulings with respect to both appeals are set out in its full written judgment, which will be notified in due course. I reiterate that it is the full written judgment that is authoritative. A summary of the challenges on appeal are addressed sequentially as follows. Alleged errors related to fairness of proceedings. As a preliminary matter, Kirsten contends that by failing to issue the full written judgment on the day that it was announced in a summary form, the trial chamber committed a serious error of law that rendered the pronouncement of the judgment procedurally defective and thus void. Moreover, he argues that the subsequent issuance of the full written judgment did not cure the defect. He asserts that the trial judges were functus officio when the full written judgment was notified, and that the rest of his appeal is therefore rendered most moot because his guilt or innocence was never lawfully adjudicated. The Supreme Court chamber notes that Khieu Samphan was fully aware of the trial chamber's intention to deliver a summary of the judgment, with a full written judgment to follow. The trial chamber publicly provided notice of its intention to do so and provided ample opportunity to the parties to raise any objections, and none were raised. Internal Rule 102.1 provides that judgments shall be issued and announced during a public hearing, and that a summary of the findings and the disposition shall be read aloud by the President or other judge of the chamber. The same rule also provides that the greffier shall distribute a copy of the judgment to the parties and ensure that it is published by the Office of Administration by appropriate means. Noting in this rule specifies, however, that such distribution or publication of the judgment must take place on the same day as the public hearing. In fact, it is not uncommon in international criminal cases of such magnitude to issue an oral summary of the judgment with written reasons to follow to allow for completion of the editorial and or translation processes. A trial judgment was thus lawfully issued and announced on 16 November 2018 in a summary form, although the full written version was distributed and published on 28 March 2019. Khieu Samphan's right to review the judgment underpinning both his convictions and his sentence remained wholly intact pending the distribution and publication of the judgment, as evidenced by the present adjudication of his appeal against the trial chamber's judgment. His submission in this respect is accordingly dismissed. Khieu Samphan further submits that over the course of the trial proceedings in case 002/02, his fundamental rights, as recognized under the legal framework of the ECCC, have not been respected as a result of the trial chamber's biased approach to the guiding principles of criminal proceedings and the rule of evidence. He argues that this fundamentally flawed approach led the trial chamber to repeatedly violate the majority of his fair trial rights and prevented it from making its findings and rulings in a fair and reasonable manner, resulting in numerous errors during the trial. His allegations of bias further extends to the trial chamber severance of case 002. He argues that the cumulative effect of these errors rendered the entire trial unfair, and he asked the Supreme Court chamber to reverse his convictions and his sentence. The Supreme Court chamber notes that with respect to his claim of bias on the part of the trial chamber, Khieu Samphan repeats his previous allegation that the case 00201 trial judgment prejudged his guilt in case 002/02, asserting that it would be impossible for the trial chamber to ignore its verdict in the previous case when deciding how to adjudicate the subsequent one. These are not novel issues and have previously been the subject of Khieu Samphan's application for disqualification of the trial and Supreme Court judges in 2014 and in 2019 respectively. A specially appointed panel of judges fully considered and dismissed the allegations of bias. In the absence of new substantiated allegations sufficient to rebut the judge's presumption of impartiality, these claims of bias are summarily dismissed. Khieu Samphan's additional allegations that the trial chamber was not impartial as to the manner in which it examined the evidence and committed other violations of his fair trial rights and the fairness of the proceedings are similarly dismissed as being without foundation for reasons explained in the full written judgment. Alleged errors related to the scope of the judicial investigation and trial. Turning to his allegations concerning Sai-Sin, Khieu Samphan raises 5 main challenges relating to the scope of the judicial investigation and trial, namely that the trial chamber erred by 1. Characterizing his request relating to the scope of the investigation as belated preliminary objections under Rule 89 and finding them inadmissible. 2. Dismissing his arguments concerning the insufficiency of the charges against him due to their lack of clarity. 3. Ignoring his arguments that it could not adjudicate facts that were not accepted and not legally qualified by the co-investigating judges, causing it to exceed the scope of its referral. 4. Delivering a judgment on facts that it had already adjudicated in Case 002/01 or on facts that it excluded from Case 002/02 and for which the proceedings were terminated. And 5. Considering the out of scope but relevant evidence about facts of which it was not seized. I will summarize the Supreme Court Chamber findings regarding those 5 challenges sequentially. Concerning his first argument, the Supreme Court Chamber agrees with the co-prosecutors that since Khieu Samphan challenges the Sai-Sin of the trial chamber based on the alleged defects in the closing order and not the jurisdiction of the ECCC itself, his challenges do not fall within the remit of absolute jurisdiction and are thus subject to cure through adequate notice of the charges. Accordingly, the trial chamber did not err in holding that Khieu Samphan's objections were subject to the deadline prescribed by Internal Rule 89.1. As to his second argument, for reasons explained in the full written judgment, the Supreme Court Chamber finds no error in the trial chamber's dismissal of his submission concerning the insufficiency of the charges against him due to the alleged lack of clarity. Regarding his third argument, the Supreme Court Chamber finds that the trial chamber did not err in law in determining its sentient of the facts contained in the closing order. It has considered Khieu Samphan's arguments concerning the scope of the trial chamber's referral and finds that he has not demonstrated any error on the part of the trial chamber for reasons explained in the full written judgment. Relative to his fourth argument, the Supreme Court chamber is not persuaded that the trial chamber erred by delivering a judgment on facts that it had already adjudicated in case 002/01 or on facts that it excluded from case 002/02 and for which the proceedings were terminated for reasons explained in the full written judgment. Finally, as to his fifth argument that the trial chamber erred in law by taking a historical approach to considering the out of scope but relevant evidence about facts of which it was not seized, the Supreme Court chamber finds no error in the trial chamber's conclusion that it may rely on the evidence outside the temporal or geographic scope of the closing order for the limited purposes of clarifying a given context, establishing by inference the elements of criminal conduct occurring during the material period, or demonstrating a deliberate pattern of conduct. Alleged errors related to the underlying crimes. I will now turn to the findings relevant to the substance of the case against Khieu Samphan, namely the crimes of which he was convicted, murder as a crime against humanity. The chamber observes that the trial chamber applied a mens rea standard of dolus eventualis when assessing the facts relevant to the crimes against humanity or murder, as it did in case 002/01, and as this chamber upheld on appeal in that case, Khieu Samphan argues that this standard was incorrect, claiming it did not exist in customary international law in 1975, and further that such a definition was not foreseeable or accessible to him at that time. The Supreme Court chamber disagrees and concludes that the trial chamber did not err. Khieu Samphan asserts that the trial chamber erred in finding that murder as a crime against humanity was established at Tram Cooperatives, Trapeng Tmor Dammed Worksite, 1st January Dammed Worksite, and Kampong Chnang Airfield Construction Site, based partly on culpable omissions without first finding that there was a duty to act. The Supreme Court chamber concludes that the trial chamber did not err.
As to whether murder was established at the following sites. Number 1, Tram Cooperatives. Khieu Samphan argues that the trial chamber erred in fact by finding that there were deaths due to starvation and rudimentary medical care at Tram Cooperatives, and erred in finding that the requisite level of intent had been established. The Supreme Court chamber concludes that Khieu Samphan has failed to demonstrate an error on the part of the trial chamber. Trapeng Tmor Dam Worksite. Khieu Samphan argues that the trial chamber erred in assessing whether the authority acted with the requisite level of intent concerning the deaths at Trapeng Tmor Dam Worksite, as there were factors beyond their control that could have led to the conditions causing death at that location. The Supreme Court chamber has analyzed his arguments and the trial chamber's findings and concludes that Khieu Samphan has failed to demonstrate error on the part of the trial chamber. Number 3. 1st January dam work site. Kilsompon argues that the trial chamber erred in finding that murders had occurred at the 1st January dam work site due to the living and working conditions imposed, including the lack of medicine, and that workers died due to accidents. He also argues that the trial chamber erred in finding that the perpetrators knew there was a lack of sufficient food and medicine, but nevertheless continues to push the workers to complete the work. The Supreme Court chambers concludes that Kilsompon has failed to demonstrate error on the part of the trial chamber. 4. Kampong Chnang Airfield Construction Site. Kilsompon argues that the trial chamber erred in finding that the deaths due to the conditions imposed were committed with the requisite level of intent because there were factors beyond their control that could have caused the underlying condition causing death at that location. The Supreme Court chamber concludes that Kilsompon has failed to demonstrate error on the part of the trial chamber. 5. Phnom Kraul Security Center. The trial chamber found that 2 deaths occurred at Phnom Kraul Security Center that amount to a murder as a crime against humanity. The first involved an inmate named Hus, who the trial chamber found had been killed by prison guards. The second involved an inmate named Tui, who died as a result of the poor conditions of detention he experienced. Kilsompon argues that the trial chamber erred by finding that both of these murders had been established beyond reasonable doubt. The Supreme Court chamber concludes that the trial chamber erred in its finding concerning the deaths of Hers and Tui, as they were clearly based on the written statements of deceased witnesses who Kilsompon was unable to confront. Accordingly, we reverse the trial chamber's findings concerning the crime against humanity of murder at Phnom Kraul Security Center. Extermination as a crime against humanity. Extermination of the Jam. The trial chamber found that murder as a crime against humanity was established in relation to intentional killings of Jam at the Wat O Trokun Security Center in 1977 and the Trier Village Security Center in 1978. It was unable to establish a definite number of victims, but was certified that a great number of Jam civilians were taken to and killed at both security centers. It found that these murders certify the requirement of killings on a massive scale and formed part of the same murder operation. The trial chamber determined that the crime against humanity of extermination subsumed that of murder and entered a conviction only for extermination. Kilsompon challenges the sufficiency of the evidence that killings occurred at the village and at Wat O Trokun. However, the Supreme Court chamber does not consider the trial chamber's findings to be unreasonable. He further challenges whether a numerical threshold for extermination had been met, since the trial chamber was unable to establish a definite number of victims, but the Supreme Court chamber concludes that the facts support the trial chamber's determination that killings on a massive scale occurred. Finally, Kyusumpon challenges whether there was intent to kill on a large scale, but the Supreme Court chamber discerns no error in the trial chamber's findings. Extermination of the Vietnamese. Kyusumpon alleges multiple factual and legal errors in the trial chamber's findings with respect to the killing of Vietnamese in Svai Rieng, in DK Waters, in Kampong Chhnang province, at Wat Ksat, and in Krache, as well as at all consigned security centers, submitting that the crime against humanity of murder and extermination could not be established in relation to any of these killings. The Supreme Court chamber concludes that Kyusumpon has failed to demonstrate that the trial chamber erred in finding that killings occurred at the above-mentioned locations. As to whether they amounted to extermination, the Supreme Court chamber discerns no error in the trial chamber's aggregation of the killings committed in multiple areas due to its finding that they were part of the same murder operation. Enslavement as a crime against humanity. Kyusumpon challenges whether enslavement as a crime against humanity occurred at Phnom Krau Security Center, alleging that the trial chamber was only seized of enslavement at one location known as K11 within Phnom Krau Security Center, and that the evidence of enslavement at K11 was insufficient. The Supreme Court chamber concludes that Kyusumpon has failed to demonstrate any error on the part of the trial chamber with respect to this issue. Deportation as a crime against humanity. The trial chamber found Kyusumpon guilty of the crime against humanity of deportation of the Vietnamese from Tam Kok cooperatives and from Prey Veng province. Kyusumpon challenges the chamber's conclusion that the Vietnamese were deported from Tam Kok cooperatives across a national border as well as from Prey Veng. He also challenges the trial chamber's finding that there was an intent to deport the Vietnamese. The Supreme Court chamber concludes that Kyusumpon has failed to demonstrate any error on the part of the trial chamber. Torture as a crime against humanity. Kyusumpon challenges the sufficiency of the evidence relied upon by the trial chamber to establish the crime against humanity of torture of the Jam at Trier village. The Supreme Court chamber discerns no error on the part of the trial chamber and concludes that Kyusumpon has failed to demonstrate that his finding that Jam were the torture was one that no reasonable trier of fact could make. Persecution as a crime against humanity. Kyusumpon asserts that under customary international law in 1975, persecution as a crime against humanity required an objective to remove the targeted persons from the community in which they live alongside the perpetrators, or even from human society in itself. In the Case 001 appeal judgment, the Supreme Court chamber addressed this issue and concluded that such an objective was not an element of persecution under customary international law in 1975. Khieu Samphan, however, argues a departure from our previous ruling, which was based on analysis of post-World War II jurisprudence. This we decline to do. Consequently, Khieu Samphan has failed to demonstrate error on the part of the trial chamber. Khieu Samphan also alleges that the trial chamber erred in law by characterizing undifferentiated treatment that has a particular impact on a class of individuals as discrimination in fact. He argues that indirect discrimination is a recent human rights concept that was not considered discrimination in fact in customary international law in 1975. With respect to this claim, the Supreme Court chamber concludes in summary as follows. Political persecution of the JAM. The trial chamber found that the JAM were targeted on political grounds and were dispersed to break up their communities. Khieu Samphan challenges this finding, claiming that the trial chamber failed to establish that the population transfers affected the JAM exclusively or at least primarily and were therefore discriminatory. Similarly, Khieu Samphan claims that the evidence fails to establish that in the course of the transfer, the JAM were treated differently from others, which he asserted was the test the trial chamber used in case 002/01 concerning new people, quote unquote. The Supreme Court chamber concludes that Khieu Samphan has misinterpreted its jurisprudence in case 002/01. It finds that the trial chamber applied the correct legal test to determine whether persecution occurred. Khieu Samphan also challenges whether the mens rea was properly established by the trial chamber, claiming that there were non-discriminatory grounds for the movement of the JAM. The Supreme Court chamber concludes that his arguments fail to demonstrate that the trial chamber's findings with respect to this issue was unreasonable. Khieu Samphan further submits that the trial chamber erred in its assessment as to whether the severity of the discriminatory acts amounts to persecution. The Supreme Court chamber concludes that the acts rise to the requisite level of severity to amount to political persecution as a crime against humanity. Khieu Samphan's arguments concerning political persecution of the JAM are dismissed. Political persecution of other real or perceived enemies, quote unquote. Khieu Samphan challenges the discernibility of the targeted group of real or perceived enemies of the CPK, quote unquote, in relation to the findings of political persecution at S21 and all consigned security centers. The Supreme Court chamber addressed this issue in case 001 and case 002/01 and concluded that political persecution was understood as encompassing situation where the perpetrators designated targeted groups in broad strokes without inquiry into the political views held by the individuals concerned. It, quote, thus confirmed the possibility that persecution as a crime against humanity might target aggregated groups without any common identity or agenda agenda, unquote. Accordingly, the Supreme Court chamber rejects Kyosompon's argument that, quote, real or perceived enemies of the CPK, unquote, is not a sufficiently discernible group for a finding of political persecution. Political persecution at cooperatives and security centers. Number 1. Trump cooperatives. Kyosompon argues that the evidence was insufficient to find that former Khmer Republic soldiers and officials and new people were persecuted at the Trump cooperatives on political grounds. The Supreme Court chamber concludes that Kyosompon has failed to demonstrate any error on the part of the trial chamber with respect to this issue. 2. The Bangtmo Dam website. Kyosompon submits that the only acts of persecution in question at the Bangtmo Dam website were the exclusion of new people from leadership positions and their being monitored by base people, which he argues is insufficient to find that any fundamental rights were violated or that the gravity requirements to constitute persecution as a crime against humanity was satisfied. Supreme Court chamber concludes that Kyosompon has failed to demonstrate any error on the part of the trial chamber with respect to this issue. 3. 1st January Dam website. Kyosompon argues that the trial chamber erred in fact by concluding that there was discrimination against people at the 1st January Dam website. 2. Erred in law by asserting that there was a fundamental right to equal treatment. And 3. Erred in law and in fact by finding that the treatment violated the fundamental right of new people to equal treatment. And 4. Erred in law by failing to set out the requisite level of gravity that needed to be met for the underlying acts to be characterized as persecution. As explained in the full written judgment, the Supreme Court chamber concludes that the trial chamber erred in finding that during the relevant time period there was a fundamental right to equal treatment laid down in international customary or treaty law that had been infringed or violated, and accordingly reverses Kyosompon's conviction for political persecution against new people at the 1st January Dam worksite. Kyosompon also argues that there was insufficient evidence to find that former Republic soldiers and officials were persecuted on political grounds at the 1st January Dam worksite. The Supreme Court chamber concludes that Kyosompon has failed to demonstrate any error on the part of the trial chamber with respect to this issue. 4. S21 Security Center. Kyosompon argues that the trial chamber erred in findings that the acts directed at, quote, real or perceived enemies of the CPK, unquote, were discriminatory in fact, and claiming that the massive scale of the arrest show that they were indiscriminate. He argues that in case 001, the Supreme Court chamber reversed the trial chamber's finding on persecution on political grounds, since it found that no discernible criteria were applied in targeting the victims. Kyosompon asserts that the evidence in case 002/02 evinced nothing new that would support a different findings in this case. The Supreme Court chamber concludes that the fact that people were arrested en masse does not preclude a finding of persecution on political grounds as long as members of the targeted group were arrested because they belong to the targeted group. The Supreme Court chamber's reversal of the eviction of persecution on political grounds in case 001 was specific to Duch Kyusampon has not demonstrated that the trial chamber erred in finding that the acts were discriminatory. 5. Okansang Security Center. Kyusampon claims that the trial chamber erred in finding that political persecution occurred at Okansang Security Center, arguing mainly that the evidence relied on does not show discriminatory treatment. The Supreme Court chamber concludes that Kyusampon has failed to demonstrate error on the part of the trial chamber. Religious persecution. The trial chamber made legal findings with respect to persecution on religious grounds in two sections of the trial judgment. The first specifically in relation to the treatment of the JAM at the 1st January Dam worksite, and the second in relation to the treatment of the JAM generally. Concerning the 1st January Dam worksite, the trial chamber found that JAM workers suffered discrimination because they were forced to eat pork, prevented from worshipping, and prevented from speaking their native language. In relation to the treatment of the JAM generally, the trial chamber found that the restrictions and the cultural restrictions were imposed included prohibition on daily prayers, forcing JAM to eat pork, forcing JAM to wear the same dress and haircuts as the Khmer people, forcing JAM to speak only the Khmer language, and burning Qurans and dismantling mosques or causing them for non-religious purposes. It was certified that these restrictions were discriminatory and were deliberately perpetrated with the intent to discriminate against the JAM because of their religious and cultural practices. Kyusampon challenges the sufficiency of the evidence that certain persecutory acts occurred at the 1st January Dam worksite and elsewhere in Cambodia. He also argues that the trial chamber erred by failing to consider whether the restriction on freedom of the religion were permissible in law. The Supreme Court chamber concludes that Kyusampon has failed to demonstrate error on the part of the trial chamber with respect to these issues. Kyusampon argues that the persecutory acts did not discriminate because they were applied equally to everyone. The Supreme Court chamber considers that the discrimination in fact can occur when there are unequal consequences for a particular group of an act or omission of general application. The Supreme Court chamber does not discern any error in the trial chamber's conclusion that the JAM were, quote, predominantly and particularly affected, unquote, by the religious and cultural restrictions so as to establish discrimination in fact. Kyusampon argues that the trial chamber erred in finding that there had been a breach of fundamental rights as none of the religious and cultural restrictions breach any of the rights the trial chamber referred to in its legal finding, noting that the trial chamber did not find that the right to freedom of religion had been breached as regards the treatment of charm generally, but only at the first January Dam worksite. The Supreme Court chamber notes that the trial chamber stated that the right to personal dignity was violated by the religious and cultural restriction at issue and considers this finding to be reasonable. Accordingly, the Supreme Court chamber rejects Khieu Samphan's arguments. Khieu Samphan also challenges whether there was intent to discriminate on religious grounds. The Supreme Court chamber concludes that Khieu Samphan has failed to demonstrate error on the part of the trial chamber with respect to this issue. The trial chamber found that the crime against humanity of religious persecution against Buddhists was established at the Tram Kok cooperatives. In particular, it found that over 100 Buddhist monks were deliberately gathered at Ong Roka Pagoda and forced to defrock. It considered that references to monks as, quote, worms, unquote, or, quote, leeches, or, unquote, and announcements dismissing Buddhism as mere superstition and the Buddha as only concrete, quote, unquote, demonstrated the discriminatory intention behind the process. The trial chamber further found that the Buddhist symbols were destroyed and pagodas used for a range of non-religious purposes across Tram Kok district. It concluded that the evidence revealed a complete abolition of Buddhist practices constituting an, quote, organized and sustained attack against religion, unquote, which was considered to be incompatible with the implementation of the revolution. Based on these considerations, the trial chamber concluded that the physical and mental impact of these events infringed fundamental rights to a degree of gravity similar to that of other crimes against humanity. Khieu Samphan submits that the trial chamber erred in finding that the religious persecution had been established, claiming there was a lack of evidence regarding the physical or mental effects of the alleged acts of persecution against Buddhists. Moreover, he asserts that because there was no evidence of discriminatory treatment against Buddhist monks and Buddhists, they were treated like the rest of the population. The Supreme Court chamber disagrees and concludes that Khieu Samphan has not demonstrated any error on the part of the trial chamber with respect to these issues.
Racial persecution. The trial chamber found that the crimes against humanity of racial persecution of Vietnamese was established at Tram Kok cooperatives, S21 Security Center, or Consign Security Center, and in Pre Vang and Svai Rieng. It found that this crime was committed as part of a policy of targeting Vietnamese for adverse treatment throughout the decade period, in particular for deportation before April 1977 and for destruction as a racial group thereafter. Because the Vietnamese were considered to be the DK's most dangerous enemy, Khieu Samphan challenges whether racial persecution occurred at any of the above-mentioned sites. The Supreme Court chamber concludes that Khieu Samphan has failed to demonstrate error on the part of the trial chamber. Other inhumane acts as crimes against humanity, Khieu Samphan challenges whether the trial chamber properly assessed the principle of legality when it found that it was both foreseeable and accessible in general that other inhumane acts were punishable as crimes against humanity by 1975. According to him, it is not enough to say that other inhumane acts were foreseeable, since this category can cover numerous types of behavior. Rather, he asserts that the trial chamber should have identified the behavior at issue and examined whether it could have defined as criminal at the time. The Supreme Court chamber is of the view that Khieu Samphan misunderstands the application of the principle of legality with regard to other inhumane acts. What is required is that the category of other inhumane acts be foreseeable and accessible to the accused, which the trial chamber found in this case. Consequently, there was no error. Khieu Samphan also asserts that conduct must breach a specific prohibition set out in human rights instruments to amount to an inhumane act. In case 002/01, the Supreme Court chamber subscribed to the approach taken by the ICTY Kupreskic trial chamber of relating other inhumane acts to conduct infringing basic rights appertaining to human beings as identified under international legal instruments. The Supreme Court chamber explained, however, that it is not required that the particular conduct must be expressly criminalized under international law, as this would render the concepts of other inhumane acts as a residual category unnecessary. Khieu Samphan's submission in this regard is accordingly dismissed. Enforced disappearances. Khieu Samphan challenges the trial chamber's findings that conduct characterized as enforced disappearances was established at Tram Cooperatives, Krang Tachan Security Center and Phnom Krao Security Center. For reasons explained more fully in the judgment, the Supreme Court chamber concludes that the trial chamber properly established that the crime against humanity of other inhumane acts through conduct characterized as enforced disappearances occurred in Tramco and at Krang Tachan and Phnom Krao. Forced marriage. The trial chamber found that the regulation of marriage was one of the CPK's policies designed and implemented to achieve a socialist revolution in Cambodia. This policy involved the commission of the crimes against humanity of other inhumane acts that occurred through conduct characterized by the chamber as forced marriage and rape in the context of forced marriage. The trial chamber thus found Khieu Samphan guilty of committing these other inhumane acts as crimes against humanity through a joint criminal enterprise. Kyusampon objects to his convictions for these crimes with respect to the regulation of marriage policy, arguing a violation of the principle of legality, disputing factual findings, and challenging the seriousness of the behavior. The co-prosecutors in turn appealed the trial chamber's ruling, which effectively excluded males as victims of forced sexual intercourse in the context of forced marriage and rape in the context of forced marriage. Kyusampon argues that the trial chamber erred in relying on international criminal case law to determine the legality of forced marriage, in allegedly failing to ascertain whether the conduct violated basic rights, in failing to consider the alleged lawfulness of forced marriage under Cambodian and other domestic regimes in 1975-1979, and in allegedly failing to properly consider the principle of a justem generis in assessing the comparative gravity of forced marriage in other conflicts. As explained in the full written judgment, the Supreme Court chamber rejects all of these arguments. Kyusampon further argues that the trial chamber erred in how it treated rape in the context of forced marriage. The co-prosecutors in turn have appealed what they assert to be errors in the trial chamber's approach with respect to male victims of forced intercourse in the context of forced marriage. Specifically, they cite the trial chamber's findings on the elements of other inhumane acts with regard to conduct charged as rape in the context of forced marriage, arguing that the trial chamber failed to make proper findings with respect to the experience of male victims of this crime. The Supreme Court chamber concludes that the trial chamber erred in its identification of the element of rape in its analysis. Rather, the chamber should have only considered the charged conduct that had occurred, being acts of forced sexual intercourse between male and female victims who had been forcibly married. This chamber further finds that such forced acts violated the basic rights of physical integrity and human dignity applicable in 1975-1979 and are of comparable gravity. We thus conclude that this conduct, properly described as forced sexual intercourse in the context of forced marriage, fell within the scope of crimes against humanity of other inhumane acts. The Supreme Court chamber thus clarifies that the victims of forced sexual intercourse comprise both female and male victims. Pursuant to our analysis, we uphold the co-prosecutor's appeal regarding errors in the trial chamber's approach to male victims. The nature and implementation of the marriage policy. Kyusampon raises various factual challenges to the trial chamber's findings on the purposes of marriage policy, namely population increase and the control of sexual interactions. He also alleges a contradiction between those two goals and asserts that to restrict male-female sexual interactions conflicts with the desire to increase the population. Kirstenporn also disputes the trial chamber's finding that the CPK principle of consent to marriage was not applied in a practice, as well as findings about both marriages of disabled soldiers and wedding ceremonies. The Supreme Court chamber rejects all of these arguments for reasons explained in the full written judgment. As also more fully explained in the full written judgment, the Supreme Court chamber similarly rejects Kirstenporn's assertion that there was no policy of forced sexual intercourse, as well as his denial that sexual intercourse was compelled. Kirstenporn also disputes the trial chamber's findings regarding instructions from the upper echelon to arrange marriages, reports on marriage to the upper echelon, and reports on monitoring the consummation of marriages, as well as his own personal involvement in the regulation of marriage. The Supreme Court chamber concludes that, for the most part, Kirstenporn mischaracterizes both the trial chamber, the trial judgment, and the evidence with respect to these matters. His submissions are therefore dismissed. The legal findings on the element of other inhumane acts. The trial chamber found that the conduct charged as forced marriage and the conduct charged as rape in forced marriage had occurred. With regards to forced marriage, it considered that serious mental or physical suffering was inflicted on individuals through the threat of forcing them to marry strangers, and the fear instilled to pressure them to consummate the marriage, and found that the conduct was performed intentionally. The trial chamber was therefore satisfied that conduct characterized as forced marriage was established and met the threshold of other inhumane acts. Please take the accused to the restroom, and we will pause momentarily and we will resume the pronouncement of the judgment when he returns.
ខ្ញុំសូមប្រកាសបន្ត
The court is now in session. With regard to the conduct charge as rape in the context of forced marriage, the trial chamber found that rape had occurred with regard to female victims and had caused serious mental or physical suffering or injury. Consequently, in the manner of that it affected female victims, such forced sexual intercourse also constituted an inhumane act. However, with regard to male victims of forced sexual intercourse in the context of forced marriage, the trial chamber concluded that, given the circumstances, they could not be considered raped victims. The trial chamber then considered whether the male victims had experienced another act of sexual violence of comparable gravity. It concluded that while the male victims indeed had experienced sexual violence that had breached their human dignity, there was insufficient evidence concerning the extent of its impact on them. Accordingly, the trial chamber concluded that the elements of other inhumane acts as crimes against humanity were not established with respect to the male victims of forced sexual intercourse in the context of forced marriage. The Supreme Court chamber has reviewed the evidence that was before the trial chamber and concludes that it was in fact sufficient to support the conclusion that male victims experience an impact comparable to that which female victims experience when forced to engage in intercourse in the context of forced marriage. It follows that such forced sexual intercourse also constituted an inhumane act as to the male victims, a factor that we have also considered in upholding the co-prosecutor's appeal regarding the trial chamber's approach to male victims. Kisampon in turn asserts that the trial chamber erred in the findings it made on the actual seriousness of forced marriage in failing to consider the context of traditional arranged marriages, which he asserts were akin to marriages under the CPK, and in the findings it made on serious mental or physical suffering or injury in the case of various individuals. The Supreme Court chamber rejects each of these assertions. Furthermore, there was no merit to any of Kisampon's challenges to evidence attesting to individual experiences of harm. Kisampon raised alternative inferences not supported by the evidence, misrepresented the evidence, mischaracterized the trial judgment, or simply disagreed with the trial chamber's findings without demonstrating any error. Kisampon next challenges the trial chamber's findings with respect to the female victims of conduct charged as raped in the context of forced marriage. The Supreme Court chamber discerns no error in the findings of the trial chamber in this regard. The co-prosecutors in turn also challenges the trial chamber's findings, but with respect to male victims, in the context of conduct charged as rape in the context of forced marriage. The Supreme Court chamber recalls its finding that the trial chamber erred in attempting to identify the elements of rape with respect to male victims, but instead should have considered only whether the charged conduct of forced sexual intercourse had occurred in the context of forced marriage. Having reviewed the evidence that was before the trial chamber, we conclude that it was sufficient to support the conclusion that the charged conduct of forced sexual intercourse in the context of forced marriage did in fact occur. Kilson-Paul argues that the trial chamber erred in its findings on harm experienced by a number of female victims, and also alleges error in the failure to consider certain other evidence. This chamber considers both of these arguments to be without merit. Indeed, Kilson-Paul misrepresents the evidence or merely disagrees with the trial chamber's findings without demonstrating any error. Genocide. The trial chamber found that the Vietnamese constituted a protected racial, national, and ethnic group during the indictment period. After determining that a number of Vietnamese were among the victims of the crimes against humanity of murder and extermination, and that the CPK targeted them because they were Vietnamese with the intent to destroy the group, the trial chamber was satisfied that genocide had been established. Kilson-Paul contends that the trial chamber erred in concluding that the killings of Vietnamese occurred, or that the killings at O Con Sang, at S21, and in Cambodian territorial waters, including at O Chơ Tia Port, were of members of the protected group. He argues that the trial chamber erred in failing to determine whether there was an intent to destroy the protected group in whole or in part, as well as whether there was an intent to destroy the protected group. The Supreme Court chamber discerns no error in the trial chamber's findings concerning the killing of Vietnamese in Svay Rieng, DK waters, Kampong Chnang province, Wat Ksait, and Krati. The chamber also concludes that the trial chamber accurately set out the applicable law as it relates to genocide. Moreover, in determining that the mens rea of genocide by killing was established, the trial chamber properly relied on factors in addition to the scale of the atrocities, such as the existence of a policy of targeting the Vietnamese for adverse treatment in DK throughout the relevant period. The Supreme Court chamber thus finds no merit in Kilson-Paul's arguments regarding genocide and rejects them as further explained in the full written judgment.
Alleged errors relating to individual criminal responsibility. Kilson-Paul's roles and responsibility during the DK period. Kilson-Paul challenges the trial chamber's findings about his roles and responsibilities during the decade. Many of these findings, combined with other evidence, underpin the trial chamber's finding about his JCE contribution, intent, and knowledge. The Supreme Court chamber has determined that the vast majority of Khieu Samporn's arguments are unfounded. He merely advances an alternative reading of the facts, one that cherry-picks the evidence and ignores large swaths of relevant evidence and fails to demonstrate that the trial chamber's assessment of the evidence was unreasonable. Grung, Deputy Prime Minister and President of the State Presidium. The Supreme Court chamber upholds the trial chamber's finding that as the Grung Deputy Prime Minister, Khieu Samporn promoted the CPK's agenda by reading press communiques of an April 1975 Special National Congress and December 1975 Third National Congress. That the trial chamber was unable to determine whether these events actually took place is immaterial to the undisputed facts that Khieu Samporn read the communiques for radio broadcast and that these promoted to the party line. The Supreme Court chamber dismisses Khieu Samporn's argument that the trial chamber could not rely on his conduct as president of the State Presidium because this role was largely symbolic, quote unquote, as he misapprehends the import of the trial chamber's description. It also dismisses Khieu Samporn's argument that the trial chamber ignored evidence that the CPK mistrusted him. The Supreme Court chamber also rejects his repeated arguments that he could not contribute to the common purpose by exercising diplomatic duties and generally by promoting the CPK party line in his speeches because he says this was not criminal in and of itself, quote unquote, or he supported only benign activities. The trial chamber's findings amply demonstrate that Khieu Samporn's speeches promoted a variety of the CPK's criminal policies. While the Supreme Court chamber agrees with Khieu Samporn that the trial chamber erred by attributing to him a speech at the first session of the People's Representative Assembly, and these errors did not occasion a miscarriage of justice as they were not indispensable to the trial chamber's corresponding conclusions. Membership in the Central Committee. Khieu Samporn concedes that he was first an alternate member and then a full member, quote unquote, of the Central Committee. In his view, the trial chamber erred by 1. Overstating the powers of the Central Committee, 2. Attributing decisions of the Standing Committee to the Central Committee, 3. Conveniently, quote unquote, dating Khieu Samporn's admission as a full member of the Central Committee in order to implicate him in the Central Committee decision of the 30th of March 1976, and 4. Finding that he participated in party congresses. The Supreme Court chamber rejects these arguments for the reasons explained in the full written judgment. The Supreme Court chamber accepts his argument that not all telegrams sent to party center reached all the Central Committee's members, but concludes he was well informed by virtue of his membership in Office 870. The Supreme Court chamber has also considered Khieu Samporn's submissions with respect to 4 decisions of the Central Committee. 1. The May 1972 decision to close markets and the use of money and organized cooperatives in the liberated zones. 2. The mid-1974 decision to close the door to party membership in order to prevent spies from infiltrating the party. 3. The June 1974 decision to undertake the final assault and evacuation of Phnom Penh in the dry season of 1974-1975. And 4. The 30th of March 1976 decision of the Central Committee regarding a number of matters. This chamber finds no error in the trial chamber's findings or in its conclusion that Khieu Samporn was aware of the first 3 of these decisions, which is solidly grounded in the evidence. The chamber discerns no error in the trial chamber's findings that the Central Committee appointed Khieu Samporn to the role of President of the State Presidium. We similarly see no reason to disturb the trial chamber's finding that Khieu Samporn contributed to the common purpose by assenting to the contents of that decision. Moreover, the conclusion of the trial chamber that he did attend the 4th and the 5th party congresses was supported by the evidence. Attendance and participation in meetings of the Standing Committee. The chamber finds no error in the trial chamber's conclusion that Khieu Samporn's frequent attendance at meetings of the Standing Committee accorded him, quote, a position of unique standing, unquote, within the party. He merely advances an alternative interpretation of the evidence and repeats arguments from cases 002/01 rather, and case 002/02 without demonstrating that the trial chamber's conclusion was unreasonable. Khieu Samporn's arguments that the trial chamber erred by holding him responsible based on his participation in meetings of the Standing Committee are unfounded. Contrary to his submissions, the trial chamber did not extrapolate from Khieu Samporn's active participation in 2 meetings that he participated on other occasions or took part in decision making, and did not hold him responsible on this basis. Khieu Samporn challenges the trial chamber's finding that he contributed to the common plan by attending Standing Committee meetings discussing Kampong Chnang airfield. The Supreme Court chamber concludes that the trial chamber erred in finding that he attended the meeting on 9 of October 1975, but this error did not occasion a miscarriage of justice. This chamber finds no error in the trial chamber's characterization of the evidence pertaining to the 2 other meetings discussing Kampong Chnang airfield. The Supreme Court chamber also finds no error in the trial chamber's reliance inter alia on a statement by the late Ieng Sari to find that Khieu Samporn attended a meeting of the Standing Committee in September 1975 where, quote, agriculture, drought, and industry, unquote, were discussed. Kyusompon argues that the trial chamber erred by relying on democratic centralism to find that he could have intervened in the Central and Standing Committee's meetings. The Supreme Court chamber concludes that the trial chamber did not rely on democratic centralism to hold Kyusompon responsible for Central Committee decisions, but on his full membership in that body. The chamber sees no error in that approach, as the trial chamber did not find that Kyusompon actively participated in standing committee meetings. His submission that he could not intervene in such meetings is moot. Residual functions. Kyusompon challenges the trial chamber's reliance on evidence of Aim Eun and Aik Hain to find that he spoke about enemies during political training sessions held at Borei-Gaila K6 and the Khmer Soviet Friendship Institute of Technology K15. The Supreme Court chamber has reviewed the evidence and found no error in the trial chamber assessment. This chamber rejects Kyusompon's submissions that the trial chamber ignored other evidence from witnesses whose account support the conclusion that he was involved in politic training. It dismisses his argument that statements, quote, relating to the CPK's general economic project, unquote, could constitute a significant contribution to the JCE. The Supreme Court chamber dismisses the submission of Kyusompon that the trial chamber erred in finding that he joined that office 870 in October 1975. He repeats arguments rejected by this chamber in case 002/01 and which failed to persuade us that the trial chamber erred. Second, this chamber rejects Kyusompon's assertion that the trial chamber exaggerated the evidence concerning his role in Office 870. Kyusompon disputes the trial chamber's findings about his role in DK trade and commerce. A number of similar challenges were dismissed by this chamber in case 002/01. Since he merely advances an alternative interpretation of the evidence, Kyusompon portrays himself as having played a minor technical role in the Commerce Committee. These submissions are similarly dismissed. The Supreme Court chamber finds no error in the trial chamber's reliance on the evidence of Sorghum Lamut, alias Sorghum Lamut, Yin Kuch, and Biet Buen, alias Bietna. The Supreme Court chamber did not consider it unreasonable that the trial chamber concluded that Kyusompon would have been aware of the contents of two letters sent to him by Amnesty International in 1977 and 1978, in part due to his connection to both the late Ieng Sary and the Ministry of Foreign Affairs. joint criminal enterprise. The trial chamber found that by the 17th of April 1975 and continuing until at least the 6th of January 1979, Khieu Samphan shared the common purpose of rapidly implementing socialist revolution in Cambodia through a, quote, great leap forward, unquote. According to the trial chamber, this common purpose was criminal because it was intrinsically linked to policies that involved the commission of crimes. These policies were 1. The establishment and operation of cooperatives and work sites. 2. The establishment of and operation of security centers and execution sites. 3. The targeting of specific groups. And 4. The regulation of marriage. The trial chamber further determined that Khieu Samphan made a significant contribution to the commission of crimes perpetrated by CPK cadres within the scope of Case 002/02, and that he shared the intent of other senior leaders in a joint criminal enterprise to participate in and commit the crimes encompassed by the common purpose. The trial chamber accordingly found Khieu Samphan guilty of committing through a JCE genocide, crimes against humanity, and grave breaches of the Geneva Conventions. Khieu Samphan submits that the trial chamber made several errors of law and fact in defining the common purpose of the senior leaders of DK as criminal. He disputes the application of a criminal label to each of the CPK's policy. He further contends that the trial chamber erred when it found that we both shared the criminal aspect of the common purpose and significantly contributed to it, as well as in finding that he intended to participate in the common purpose and in the crimes underlying it. Some of the legal errors alleged by Khieu Samphan concerning the trial chamber's statement of the law applicable to JCE. For instance, he submits, among other things, that culpable omission is not sufficient to establish participation in a common purpose, and that the requisite link must be between a JCE member and all direct perpetrators of a crime, and not just one such perpetrator. For reason explained in the full written judgment, the Supreme Court chamber dismisses Khieu Samphan's assertions in this regard as they fail to demonstrate any appealable error. Criminality of the common purpose. Khieu Samphan repeatedly objects to how the trial chamber concluded that the CPK's plan for socialist revolution was criminal in nature. The Supreme Court chamber recalls that in order to give rise to criminal liability, the common purpose, that is, the object of the planned action among several persons, must be of a criminal character, in this sense that it either amounted to or involved the commission of a crime. Khieu Samphan claims that the common purpose of rapidly implementing socialist revolution in Cambodia was not criminal in nature, but rather was a purely political move. That characterization ignores the fact that the underlying plan was to use any means necessary to achieve the socialist revolution in the country, including the crimes that were committed on a massive scale against the Cambodian people throughout the implementation process. The Chamber considers that by no stretch of the imagination could it be seriously stated that the CPK revolution was implemented in a benevolent or altruistic manner. While there may have existed socialist revolutions that have taken place without bloodshed or criminal activity, this was not one of them. Kyusampon claims of error regarding the trial chamber's approach in determining the criminality of the common purpose are accordingly dismissed. Kyusampon further submits that the trial chamber misconceived the CPK's notion of enemies and wrongly established the existence of a policy to eliminate them at security centers and execution sites. He asserts that the trial chamber's error precluded the conclusion that crimes against humanity were committed at the S21, Krang Tachan, Okansang and Phnom Krao security centers, and repeatedly asserts that the trial chamber fails to view the evidence in its proper context, namely that of armed hostilities against the Lon Nol regime and subsequently Vietnam. This chamber thoroughly reviewed the evidence with respect to the trial chamber's approach to real and perceived enemies of the CPK and concludes that Kyusampon arguments are without foundation. The errors alleged by him as to the trial chamber's finding regarding the existence and criminality of a policy to establish and operate security center and execution site during the decay era are thus dismissed. With respect to establishing cooperatives and work sites, Kyusampon disputes the trial chamber conclusion that this policy was intrinsically linked to the common purpose and involved the commission of crimes against humanity. He contends inter alia that the trial chamber mischaracterized the CPK's political orientation regarding the cooperatives by selectively reviewing official CPK documents through an incriminating lens of, quote, amity, unquote, and ignoring exculpatory evidence demonstrating that there was a constant concern for the population. While it is not necessary to refer to every piece of evidence on the trial record, the trial chamber did in fact refer to most of the documents to which Kyusampon points, and his alternative interpretations of those documents do not suffice to overcome the trial chamber's conclusions based on its own fair and reasonable interpretation and those same documents. his allegations of error regarding the existence and criminality of a policy to establish and operate cooperatives and work sites during the decade era are thus dismissed. Policy of targeting specific groups and regulating marriage. Turning to policy of targeting specific group, the Supreme Court Chamber concludes that Khieu Samphan has not demonstrated that the trial chamber erred in finding that the policy broadly targeted Buddhists, Cham, Vietnamese, and former Khmer Republic soldiers and officials for the reasons explained in the full written judgment. As to the policy of regulating marriage, Khieu Samphan submits that it was not possible to find this existence of a criminal policy regarding the organization of forced marriage and the commission of rape in this context. For reasons explained in the full written judgment, the Supreme Court Chamber has rejected his assertions, his allegations of error in the findings regarding the existence and criminality of a policy to regulate marriage during the decade era are thus dismissed. Khieu Samphan's contribution. The two remaining essential JCE issues relate to Khieu Samphan's contribution to and intent to participate in the common criminal purpose. He submits that the trial chamber wrongly found that his support for and participation in and/or contribution to the political process for the purpose of implementing a socialist revolution in Cambodia were sufficient to establish his significant contribution to the commission of any crimes such purpose may have involved. The Supreme Court Chamber recalls that the contribution to a JCE may take many forms, and as previously determined by the Chamber, quote, even activities that are on their face unrelated to the commission of crimes may be taken into account when determining whether the accused made a significant contribution thereto, unquote. The Supreme Court Chamber accordingly rejects Khieu Samphan's argument that the trial chamber could not take into account his activities that were on their face directed at implementing a socialist revolution as opposed to the commission of specific crimes when determining that he made a significant contribution to furthering the JCE common criminal purpose. The Supreme Court Chamber similarly rejects Khieu Samphan's submission that the trial chamber essentially imposed on him a form of collective responsibility, quote unquote, or guilt by association, claiming that the trial judgment clearly shows that it based its conclusions about his significant contribution to the JCE on his own conduct or acts as opposed to those of others. Khieu Samphan's allegations of error regarding his significant contribution to the JCE's common criminal purpose are thus dismissed. Khieu Samphan's knowledge and intent. As to whether he knew of and intended the commission of the crimes underlying the encompassed by the common purpose, Khieu Samphan disputes the trial chamber finding that he did and reiterates that the common purpose was not criminal. Khieu Samphan does not deny that he and the other members of the enterprise shared a common intent of transforming Cambodia into a self-sufficient, classless agricultural society through a socialist revolution, but he continues to assert that they never intended to commit crimes individually or as a group, and that their common purpose was benign and for the benefit of the population of Cambodia. He argues that any crimes that might have occurred in the process of implementing the common purpose were extraneous thereto and happened without his knowledge and participation. A review of the trial judgments shows that the trial chamber fully examined and applied the mens rea requirement of the JCE for each of the crimes alleged. Moreover, it conducted this exercise in relation to Khieu Samphan's imputed knowledge as a senior leader and active participant at the heart of the CPK, and his close relationship with those at the highest level of its leadership. Contrary to his assertion that the trial chamber improperly imposed a, quote, vicarious criminal liability, unquote, on him, the Supreme Court chamber finds that the trial chamber inferred his intent from his own acts and conduct. The Supreme Court chamber observes that in concluding that Khieu Samphan had the requisite mens rea under JCE, the trial chamber clearly concluded that he had direct contemporaneous knowledge of the commission of crimes and shared the intent for their commission with other JCE members. The several errors that Khieu Samphan alleged with respect to the trial chamber's findings regarding his contemporaneous knowledge and shared intent to commit crimes at cooperatives and worksites, at security centers, and against specific groups, namely the Cham, Buddhist, Vietnamese, and former Khmer Republic officials, are dismissed for reasons explained in the full written judgment. The Supreme Court chamber similarly rejects Khieu Samphan's assertion that the trial chamber erred in concluding that he knew of and intended to commit crimes in regulating marriage. The Supreme Court chamber has addressed in the full written judgment Khieu Samphan's arguments in support of these contentions. For the most part, they simply constitute alternative interpretation of the evidence. Khieu Samphan's assertion of error are thus dismissed. Applicability of JCE liability to crimes committed with Douglas eventualists. As a final JCE-related matter, the Supreme Court chamber has determined proprio motu that the trial chamber erred in its application of the law relating to JCE liability for crimes committed with dolus eventualists. Although none of the parties advanced this issue on appeal, the Supreme Court chamber considers it necessary to address, as it is of general significance to the ECCC's jurisprudence. The trial chamber determined, quote, that the degree of intent required under JCE1 is direct intent, unquote, and that, quote, indirect intent or dolus eventualis. Again, the trial chamber determined, quote, that the degree of intent required under JCE1 is direct intent, unquote, and that, quote, indirect intent dolus eventualis does not suffice for a finding of JCE before the ECC, unquote. As a result, the trial chamber concluded that a crime against humanity of murder committed with dolus eventualis fell outside the common purpose of the JCE and accordingly analyzed Khieu Samphon's responsibility for this crime under the mode of liability of aiding and abetting instead. The Supreme Court chamber concludes that the trial chamber erred when it failed to apply our holding in case 002/01 that an accused may be held liable for crimes that are not directly intended but are nevertheless encompassed within a JCE common purpose. In this respect, the Supreme Court chamber recalls its finding in case 002/01 that liability under JCE for crimes that fell outside the common purpose, that is JCE 3, was not part of customary international law in 1975, and that liability under JCE before the ECCC could therefore only arise for crimes falling within the common purpose. The trial chamber incorrectly concluded that if the commission of a crime is merely foreseeable, that crime automatically falls outside the common purpose. This ignores situations where the probable commission of a crime was jointly and willingly agreed upon or accepted by all JCE participants. In such situations, as the JCE participants share an agreement regarding the commission of a crime with dolus eventualis in furtherance of the common purpose, the crime is encompassed by the common purpose. The trial chamber's error led it to determine that murders committed with dolus eventualis at the following location fell outside the JCE common purpose. The Tramkok cooperatives, the 1st January Dam worksite, the Trapang Tmor Dam worksite, the Kampong Chnang airfield construction site, the S21 Security Center, the Krang Tachan Security Center, and the Phnom Krao Security Center. The trial chamber determined that Khieu Samphon was instead culpable for aiding and abetting those murder with dolus eventualis. For reasons explained in the full written judgment, the Supreme Court chamber finds that the crime against humanity of murder with dolus eventualis at these locations was encompassed by the JCE's common purpose, and that Khieu Samphon made a significant contribution thereto with the shared intent to commit this crime while being aware of the substantial likelihood of deaths. Phnom Krao Security Center is excluded from this analysis because as previously discussed, the Supreme Court chamber reversed the trial chamber finding that the crimes against humanity of murder was established with respect to that location. The Supreme Court chamber accordingly recharacterizes the form of liability from aiding and abetting to JCE for the crime against humanity of murder with Dollars eventualist at the Tramkok Cooperatives, 1st January Dam Work Site, Ropiang Mall Dam Work Site, Kampong Chnang Airfield Construction Site, S21 Security Center, and Krang Tachan Security Center. It therefore will not consider Khieu Samphon's remaining challenges related to aiding and abetting.
Sentencing. The Supreme Court chamber recalls that Khieu Samphon currently serves a life sentence, the maximum sentence permitted at the ECCC, which was imposed by the trial chamber in case 002/01 and upheld by the Supreme Court chamber on appeal. Case 002/01 and 002/02 were prosecuted separately but originated from a single indictment that was severed in the interest of trial management and in light of the frail health and advanced age of all the accused. Although the two cases are thus related, they deal with different facts that were adjudicated in two trials that produced separate dispositions, each of which requires the imposition of a separate sentence after a finding of guilt. For this reason, the trial chamber sentenced Khieu Samphon to life imprisonment for the crimes of which he was convicted in case 002/02, and we affirmed that sentence. The Supreme Court chamber considers the life sentence that was imposed in case 002/02 to be appropriate in light of all the circumstances, including the tragic nature of the underlying events and the extent of harm caused by Khieu Samphon. In the circumstances, however, in addition to affirming the life sentence in this case, we affirm the decision of the trial chamber to have the sentence run concurrently with the one imposed in case 002/01 as permitted by Article 138 of the Cambodian Criminal Code. Nonetheless, Khieu Samphon has raised several challenges to the fairness of the sentence imposed by the trial chamber in case 002/02. He argues that the trial chamber erred in describing the primary objective of sentencing, that it erred in its assessment of the gravity of the crimes by including in its analysis a crime for which he was not charged, that it erred in its assessment of aggravating factors, including the double counting of his positions of authority and influence as an aggravating factor as to the gravity of the crimes, and finally, that it erred in assessing mitigating factors. The Supreme Court chamber has thoroughly considered each of these assertions and considers them without merit. The sole exception is the claim that the trial chamber erred in both assessing the gravity of the crimes committed by including a crime of which Kirsampon was not charged and impermissibly double counting his position of authority and influence. Although the Supreme Court chamber decides that doing so constituted error, it also concludes that in the circumstance of this case, their consideration does not render the ultimate sentence inappropriate or unfair in any way. Dispositioned. For the foregoing reasons, the Supreme Court chamber, pursuant to Article 4.1b of the ECCC Agreement, Articles 14 new 1b and 36 new of the ECCC Law and Internal Rule 111, noting the respective written submissions of the parties on appeal and their arguments presented at the hearing from 16 to 19 August 2021, grants in part and dismisses in part Kirsampon's appeal, and therefore, insofar as it relates to facts of death that occurred at Tramkok Cooperative's Trapengtmo Dam worksite, 1st January Dam worksite, Kampong Chnang Airfield Construction Site, S21 Security Center, and Krang Tachan Security Center, reverses Kirsampon's conviction for aiding and abetting the crime against humanity of murder with dolus eventualis and recategorizing the facts, enters a conviction for the crime against humanity of murder with dolus eventualis through a joint criminal enterprise, insofar as it relates to facts of death that occurred at Phnom Krau Security Center. Reverses Kirsampon's conviction for the crime against humanity of murder at Phnom Krau Security Center, insofar as it relates to facts of persecution at 1st January Dam worksite, reverses Kirsampon's conviction for the crimes against humanity of persecution on political grounds of new people at the 1st January Dam worksite, insofar as it relates to facts of killing of the Cham that occurred at Tri Village and Wat O Trokun, and killings of the Vietnamese in Svai Rieng, in DK Waters, in Kampong Chnang Province, at Wat Ksach and in Krati, as well as at O Consign Security Center, affirms Kirsampon's conviction for the crimes against humanity of extermination, insofar as they relate to facts of forced labor of prisoners at Phnom Krau Security Center, affirms Kirsampon's conviction for the crime against humanity of enslavement. Insofar as they relate to facts of removal of the Vietnamese from Tramkok district and from Prevang province, affirms Kirsampon's conviction for the crimes against humanity of deportation of Vietnamese. Insofar as they relate to the facts of physical and mental mistreatment of the Cham at Tri Village, affirms Kirsampon's conviction for the crime against humanity of torture. Insofar as they relate to the facts of the treatment of the Cham and of real or perceived enemies of the CPK, including former Khmer Republic soldiers and officials, and new people and Trump cooperatives dropping them worksite, first gender them worksite, not in relation to new people, Kampong Chnang Airfield Construction Site, S21 Security Center, Krang Tachan Security Center, or Konsai Security Center and Phnom Krao Security Center, affirms Khieu Samphon's conviction for the crimes against humanity of persecution on political grounds. Insofar as they relate to facts of discrimination against the child, affirms Khieu Samphon's conviction for the crimes against humanity of persecution on religious grounds. Insofar as they relate to facts of discrimination against Buddhist and Buddhist monks, affirms Khieu Samphon's conviction for the crimes against humanity of persecution on religious grounds. Insofar as they relate to facts of discrimination of the Vietnamese at Trump cooperatives, S21 Security Center, O Konsai Security Center, and in Privek and Svay Rieng provinces, affirms Khieu Samphon's conviction for the crimes against humanity of persecution on racial grounds. Insofar as they relate to facts of disappearances at Trump cooperatives, Krang Tachan Security Center and Phnom Krao Security Center, affirms Khieu Samphon's conviction for the crimes against humanity of other inhumane acts through conduct characterized as enforced disappearances. Insofar as they relate to facts of forcible transfers of the child, insofar as they relate to facts of forcible transfer of the child in the course of the movement of population phase 2, affirms Khieu Samphon's conviction for the crimes against humanity of other inhumane acts through conduct characterized as forced transfer. Insofar as they relate to facts of forced marriage and forced sexual intercourse in the context of forced marriage, within the context of the nationwide regulation of marriage, affirms Khieu Samphon's conviction for the crimes against humanity of other inhumane acts through conduct characterized as forced marriage and rape, and additionally categorized as crime against humanity of other inhumane acts in the form of sexual violence understood to constitute forced sexual intercourse in the context of forced marriage with regards to female victims, grants the co-prosecutor's appeal, and enters a conviction for the crimes against humanity of other inhumane acts through conduct characterized as forced marriage and additionally categorized as crime against humanity of other inhumane acts in the form of sexual violence understood or to constitute forced sexual intercourse in the context of forced marriage with regard to male victims. Insofar as they relate to willful killing, torture, inhuman treatment, willfully causing great suffering or serious injury to body or health, willfully depriving prisoners of war or civilians the rights of fair and regular trial, and the unlawful confinement of civilians, affirms Khieu Samphon's conviction for grave breaches of the Geneva Conventions. Insofar as they relate to the facts of killings of the Vietnamese, affirms Khieu Samphon's conviction for the crime of genocide. affirms Khieu Samporn's sentence of life imprisonment in case 002/02, which shall run concurrently with the life sentence imposed in case 002/01. Orders that Khieu Samporn remained in the custody of the ECCC pending the issuance of the full written appeal judgment and the finalization of arrangements for his transfer in accordance with the law to the prison where he will continue to serve his sentence. 60 officers, please take the accused back to his cell. The chamber declares the closure of the pronouncement. All rise.